Moot Problem. The Moot Problem deals with some of the real-time issues which many companies are facing under the GST regime. The Moot Problem primarily deals with two transactions. Transaction number one, TechZ has launched a next-generation smartphone model, the Z Next. The smartphone model is being offered at a price of 38,870. As part of a promotional offer, along with the phone, TechZ is offering a free Bluetooth headphone and free power bank also manufactured by TechZ. The free power bank and Bluetooth headphone can be claimed at any point in time within 6 months from the date of purchase of the phone. But a phone requires to be purchased to claim the free power bank and the free Bluetooth. The Bluetooth headphones and the power banks are also sold as separate items in the retail market and are priced at rupees 1199 and rupees 1499 respectively. TechZ avails of input tax credit on the goods and services used for the manufacture of the smartphones and also input tax credit on the goods and services availed for the manufacture of the Bluetooth headphones and power banks, which are supplied free of cost along with Z Next smartphones. Transaction number two, also one of the transactions which TechZ undertakes, is that TechZ has entered into a long-term agreement with Encrypt, a leading desktop and laptop manufacturer in the Indian market headquartered at Bombay. As per the terms of the contract, Encrypt has guaranteed to buy 30,000 units of microprocessors from TechZ for 3 years at a rate of 5,000 per unit. The same microprocessors are sold in the outside market at the rate of 6,100 per unit. The agreement between TechZ and Encrypt specifies that Encrypt would display the insignia logo of TechZ on every desktop and laptop which contains these microprocessors, stating powered by TechZ, and that all advertisements by Encrypt advertising the product will have the name and logo of TechZ. In these facts, now the matter is presently before the Delhi High Court. The Delhi High Court has issued notice to the respondents on the writ petition filed by the petitioner. The High Court has also prima facie held that as the matter relates to interpretation of legal issues, alternate remedy would not be a bar for exercising writ jurisdiction under Article 226. The questions of law which have been framed and which are currently there before determination before the High Court are: number one, whether the supply of the free Bluetooth headphone and free power bank as a part of the promotional offer under transaction number one could be treated as goods disposed of by way of gift for the purpose of section 17(5)(h) of the Central Goods and Services Tax Act, and whether ITC may be availed by the petitioner on the free Bluetooth headphones and free power bank which were given on purchase of specified TechZ phones. In the alternative, if such supplies were to be treated as free supplies, since ITC has been availed, input tax credit has been availed on such free supplies, whether such free supplies would be deemed to be supplies made without consideration, and as such whether GST is liable to be paid on such deemed supplies under Schedule 1, Article 1. The second question, whether price is the sole consideration in the supply of microprocessors by TechZ to Encrypt in transaction number 2, and whether the petitioner is liable to pay GST on the open market value of the microprocessors. Question number 3, whether the clarification issued by the Ministry of Finance in the form of frequently answered questions or FAQs has any legal validity, and whether the same is binding on the GST authorities. And question number 4, whether the pending writ petition before the Delhi High Court can bar the SGST authorities from initiating any further action under their respective provisions. Without much further ado, I would now call upon Shri Sujit Ghosh, counsel for the petitioner, to make his submissions before the bench.